A couple of words about our webinar. So this is the cross-jurisdictional webinar where we will be discussing the question of international taxation. And my colleagues from Russia and Kazakhstan will be together to discuss the implementation of BEPS MLI, International Convention, in our jurisdictions. Within our webinar, we will focus on the legal nature of this document, the main provisions, the main articles, peculiarities of implementation of this convention in Russia, Kazakhstan, and Ukraine. And during our webinar, you will be able to ask questions. Please use function question and answers for this. And we will answer them either during the webinar or at the end of the presentation. So we are still waiting for a couple of participants to join, and in the meantime, I would like to introduce to you my colleagues, Ekaterina Lokatosh, tax team leader from Moscow office of Schneider Group.
Hello, colleagues.
And Maria Nazarova, tax team leader from Almaty office of Schneider Group.
Hello, dear colleagues.
So I see that quite many participants already joined us, and I think we can gradually start the presentation. So as a foreword, Ekaterina will start with a description of the general notion of multi-level instrument, its purpose and mechanism of implementation. Then we are going to speak about the particular articles of this document and how they should be implemented in different jurisdictions. And as well, at the end of our webinar, we also discuss on what situation it might create for business and how Schneider Group can help you in these situations. So without further ado, I give a word to Katya. Katya, the floor is yours. Let us start.
Thank you, Artyom. First of all, I would like to note the place of MLI among sources of law which regulate tax-related issues. All we know that in each country we have national tax legislation. We have as well a law enforcement practice according to which we can judge how these law provisions are implemented in the country and how they are usually understood. Usually in local tax legislation, we have provisions according to which international agreements have more legal force in the countries. So double taxation treaties, which are aimed to avoid a double taxation of income of relevant legal entities from contracting states, are related to international agreements. And MLI, which is standing above all this structure, is introducing changes in double taxation treaties. The mechanism is following. The company joins the country joins the text of MLI, signs it, and while signing gives different disclaimers according to which we can understand which provisions of MLI will be applicable to double tax treaties of this country with other countries and which will not be applicable. The experts say that changes of all double tax treaty would take about 20 years of work of different government bodies, but MLI allowed to introduce changes very fast. And let's see what this instrument is. Next slide. MLI was elaborated in the frame of point 15 of the BEPS plan. Let me remind you that BEPS plan is aimed to prevent tax erosion and profit shifting out of taxation. At present, 94 countries have signed this convention. But it does not mean that changes will be introduced in double tax treaties of all these countries. In different countries, the procedure of adoption of this convention is different. For example, in Russia, it should be adopted by parliament after signing, and then the relevant documents should be submitted to OECD. Each country should perform this procedure, and you can check current status of MLI on the link which you can see on the slide, and to understand whether this country at present applies MLI or not. The situation is changing, so before planning the operation, you can check what is the current status. And as I said, while joining to MLI, each country leaves some disclaimers and some notes how it will be implemented and which option provided by MLI will be used and with which countries. So at present, we have on the site of OECD MLI matching database, when you can compare the status of disclaimers of each contracting state and understand what kind of provisions will be implemented by each country. When the provisions which have chosen each of the country are coincident, that means that this provision will be implemented in relations between two countries. Actually, it is a very complicated process of understanding which provisions are implemented, and OECD recommended to each country to republish each double tax treaty in which changes will be introduced. For example, in Russia, this is not done yet, but we hope that from the next year, when it will start to be implemented, we will have this information. Next slide, please. So as I said, in Russia, this document will start to be implemented from the next year. But it was signed in 2017 and ratified in 2019. Please note that Russia will spread MLI over 71 double tax treaty. As most of our clients are German and Switzerland and Austrian countries, it is very important to note that Russia is excluded Germany and Switzerland from the list of countries with which MLI will be implemented. But for example, Austria is in the list. Next slide, please. So on the next slide, on this slide, you can see the list of countries with which Russia will start implementing MLI starting from 2021. It was published on the official site of Ministry of Finance, and they said as well in this notification that they will continue informing the taxpayers about coming into force of MLI provisions with other countries. So till at present we have notifications about coming into force of MLI with these countries. Let's see what situation in Ukraine and Kazakhstan. Dear colleagues, please share your information.
Thank you, Katya. Thank you, dear participants, for joining us during this webinar. My name is Maria, and I will tell you in short about Kazakhstan's status with MLI. MLI was signed by the Republic of Kazakhstan on 25th June 2018, and it was ratified this year on 20th of February. MLI will come into force actually today, and actually will be applied from 2021, from the 1st of January, as most of countries which joined MLI. Kazakhstan itself plans to introduce amendments to 45 double tax treaties out of 55. Actually, this is in short about the status of MLI in Kazakhstan, and I am asking Artyom to proceed with Ukrainian status.
Yeah, thank you, Maria. Speaking of Ukraine, MLI was signed in our country in July 2018, ratified in February of 2019, and became effective in December of the same year. However, it came into force gradually, so provisions for income tax for non-residents came into force as of January of the current year, and in respect of other taxes, starting from 1st of June of this year. Ukraine plans to apply actually changes to all of its double tax treaties, which are 76 in number currently. So now we are going to describe the particular articles of convention, and we will start with the part dedicated to prevention of misuse of double tax treaties provisions.
So we will start with Article 4, which is related to dual residency of different legal entities. This article provides that legal entity can be, if it is recognized as a resident of 2 or more states, should apply for clarifications to relevant competent authorities in order to resolve the situation and understand whose resident it is. Until this issue is not solved, the legal entity cannot apply for exemption. This case derives from the situation when in some countries residentship is defined upon the place of registration, and in some countries upon the place of actual management. So it can be, the situation with residentship can be unclear, therefore. And only through mutual agreement procedure, the competent authorities of 2 states can decide and solve this issue. So in practice of Russia, it was not. Next slide, please. Yes, in practice of Russia, it was not implemented before, and we are not aware how it will be implemented in the future. But let's see what is the situation in Ukraine and Kazakhstan.
From Kazakhstan side, I just wanted to know that in its ratification note that was submitted by Kazakhstan, it is stated already that double tax treaties of Kazakhstan already contain provisions that is mentioned in Article 4. Artyom, what is in Ukrainian?
Speaking of Ukraine, we decided not to apply Article 4 in the treaties of Ukraine. So going forward, next article is number 6. This article introduces the changes to preamble of double tax treaty, and actually it adds the following provisions.
I'm sorry for interrupting. Maybe the microphone. Yes, please.
Yep. Thank you. So the following provisions should be added to the preamble of double tax treaty. So first of all, it is intention to eliminate double taxation with respect of taxes covered by the particular double tax treaty. Second, it is important to know that application of double tax treaty should exclude the opportunities for non-taxation on or reduced taxation through tax evasion or tax avoidance. And also important part of the preamble is elimination of so-called treaty shopping. Treaty shopping, this means an arrangements, artificial ones aimed at obtaining reliefs of granted by double tax treaty by residents of the third jurisdictions, and for the purpose of getting these benefits, to create some artificial structures in that jurisdictions which has suitable taxation regime. On one hand, one might say that preamble is not that important. This has only formal meaning, but it should be noted that in the court practice and in international arbitrage practice, it is important to understand what is the goal of international document and what are the aims this international treaty has. And only on this basis, according to the international treaty on international agreements signed in Wien in 1968, the court and state authorities can interpret the provisions of international agreements. That is why putting such statements about elimination of possibilities for tax evasion, tax avoidance, elimination of treaty shopping is quite important to understand, for understanding of the nature of this document, and also it would reduce the possibilities to abuse the benefits of double tax treaty when they are used not for the purpose of which are mentioned in the preamble of a particular document. In addition, the preamble also could be supplemented by the text referring to a desire of contracting parties to develop economic relationships and enhance cooperation in tax matters, which is also important because the MLI itself prescribes certain procedures of cross-border cooperations. And as we know, the whole BEPS process is also aimed at more transparency and enhancement of international tax cooperation. So MLI also adds its share to development of these processes. So this was comments on implementation of Article 6 in Ukraine. And now, colleagues, please let us know what is the situation in Russia and Kazakhstan.
So in Russia, the change of preamble will also take place, as I agree with your term that this provision is very important, as the aim of double tax treaty should be in the loop while implementing of this document. So Maria, what are you seeing in Kazakhstan?
In Kazakhstan, actually, we have already preamble provisions in double tax treaties, so we are not expecting any changes right now.
Okay, thank you.
Okay. With regard to Article 7, prevention of treaty abuse, here we would like to know that the provisions of this article state that an application of benefits of double tax treaties in form of exemption or reduction of tax rates, if the relevant obtaining of benefits was the main purpose of the conclusion of the agreement, is actually prohibited. In order to make it possible, by Article 7, were introduced such conditions as principal purpose test and simplified limitation of liabilities. On the next slide, we will see a picture in which we will try to show how it expected to work principal purpose test in Kazakhstan. For example, company A and company B are going to conclude a technical service contract, and in these countries, state A and B, where these companies are registered, actually there are no double tax treaty between these countries. And to solve and to make it more beneficial for these companies, they decide to find another company C with registered in another state with which company B and state A have available double tax treaty. They conclude agency agreement with company C, both company A and company B, and they by this agreement they are not adding any value. They're just trying to make less taxes for the companies. In this case, if this will be revealed, then these companies are not allowed for using actually tax benefits which is provided by double tax treaties. Actually, this norm is obligatory for all participants of MLI, so this norm will be applied by all countries which accept MLI agreement. Next slide, please. Here in this, at this point, I just wanted my colleagues to ask whether and how these provisions will be applied in Russia and Ukraine.
So in Russia, we have a very broad practice, which further was adopted in legal in legislation. From 2006, we have the term unjustified tax benefits, and starting from 2014, the tax legislation, the tax court practice started to implement understanding of beneficial ownership. The court started checking if the foreign company has real beneficial ownership on income, and started provide reduced tax rates only when it is confirmed. We are not expecting lots of changes in implementation of this rule. However, in most of double tax treaties, this change will be introduced. For example, with double tax treaties with Cyprus, Netherlands, and Luxembourg. Artyom?
Speaking of Ukraine, yes, we also implement this principal purpose test. In terms of the local legislation and application of such provision further, we also have the changes actually which became effective in May of the current year. They generally correspond to the notion of business purpose mentioned in MLI, and they are dedicated to transactions of Ukrainian taxpayers with non-residents. So previously we did not have such practice, but now it is expected that Ukrainian tax authorities will control the business purpose of transactions with non-resident, and if they find any discrepancies or misuse, they will act accordingly and try to accrue additional taxes and respective penalties. In addition, it is interesting to note that Ukraine also shall apply the provision of MLI that states describe the situation that the treaty benefit might still be provided to an enterprise if the competent authority makes an investigation by request of such taxpayer, and as a result of this investigation it will be proved that the person would still be entitled to the treaty benefit even without this suspicious arrangement which actually failed the principal purpose test.
Thank you, colleagues. Going forward to simplified limitation of benefits, this provision actually defines specific conditions when benefits of double tax treaty can be applied. And here we see, first of all, two main categories for which actually double tax treaties benefits are provided. They're for qualified persons or for residents that can active entrepreneurial activities and income generated from these activities connected with such activity in the country for which they apply double tax treaty. At that active entrepreneurial activities, here it's important to note that are not include such companies as holding companies, group management companies, providing group funding, making and management investments, and companies that are generating passive income. Exceptions for these companies, legal entities, 75% of which are owned by an equivalent beneficiary within a period of 6 months, or legal entities with 50% of which is owned by qualified person, also for the period of 6 months. What it means? It means, for example, as you see on the picture on the slide, if, for example, Kazakhstani company is paying dividends income to the company which is holding company, for example, in the Russian Federation, in this case, double tax treaty cannot be provided. This simplified limitation of benefits actually was chosen not by many countries, and we see that with Kazakhstan only 5 states were accepted, which accepted these provisions. It includes India, Armenia, Russia, Bulgaria, and Slovakia. Colleagues from Ukraine and Russia, please share your vision with regard to this position.
Russia will apply this rule, but it will not be widely implemented. With only several countries it will be applied, for example, with India and China.
And Ukraine decided not to apply this rule in the double tax treaties.
So colleagues, let's move to next provision, which is Article 8, dividend transfer transactions. So all previous provisions which we have described to you was mandatory provisions which countries should choose if it is joining MLI. All following provisions are considered as optional, means country can write a disclaimer by joining MLI if he wants to apply this provision or not. So provision regarding dividends transfer is aimed to avoid misuse of double tax treaties when some thresholds are established for using of reduced tax rates, and in practice there was cases when these thresholds were met only before dividend distribution. For example, the situation when the company should have at least 10% of participatory interest, and which should form the certain amount of charter capital. So the company could introduce changes into the corporate documents of the country and increase charter capital in order to use this provision right before the dividend distribution. And now it will not be so easy. Next slide, please. So on the slide, you can see that according to double tax treaties between Russia and France, a reduced tax rate is in amount of 5% is applied only if the company has participatory interest in the other company in amount of 10%. So now it will be important that this level of investment will be maintained within 365 days before the date of dividend distribution. So if this new condition is not met, the reduced tax rate will not be implemented, and the usual tax rate should be applied. In Russia, this provision will be applied with such countries like Argentina, Armenia, and Netherlands, and some other countries. So, colleagues, what is the situation in Ukraine and Kazakhstan?
I just want to say about Kazakhstan. Kazakhstan actually accepted to apply 365 days holding period, and it is mentioned that this condition will apply only if contracting state will also use this position. Based on MLI matrix database, we see that already 8 states, together with Kazakhstan, accepted this provision, and 3 states are currently under the question because there are some mismatching provisions. Artyom, what is in Ukrainian?
As you can see, in Ukraine, this provision will not be applied.
Okay.
So we are going forward to Article 9. It is dedicated to capital gains from alienation of shares or interest in entities deriving their value principally from immovable property. Why this article was introduced? Just a couple of examples. So under the normal situation, the provisions of double tax treaty state that if there is a alienation of property in one state, actually the income from this alienation has to be taxed in that state. So in order to avoid this provision and not to pay the taxes in the state of residence, state of location of immovable property, there was quite a practice to transfer such immovable property to the company and then to sell the participatory shares in the company. So in that case, it could be possible to avoid such additional tax on capital gain. At the same time, in some of double tax treaties, it was prescribed that still, even if the immovable property belongs to an enterprise, the company needs to have a certain share. This property should constitute certain share of value into this into the total assets of this company in order to be taxed in the state of the location. But there was also another harmful practice to invest any other interest, shares, assets into the company just to reduce the share of immovable property into the total value of assets, and in that way to avoid the taxation. So in order to counteract this practice, it was decided that, and speaking of my previous comment, these investments were made right before the sale of the shares in the company which is owner of the property. So it was decided that there should be a period of 1 year within which the value of immobile property should be more than 50% in the total value of the company's assets. And in this case, it will be necessary still to pay the tax in the state of this property location. This introduction of this period would avoid the practices of changing the value of the company into the total value of assets of the owner of this property, and I think it would bring more stability to taxation, that the sellers of company which owns the property will not be able to make any changes within the 1 year period, or otherwise they will have to the tax will have to be paid out of income received for the sale of the company. So this provision is quite popular. It was chosen by 37 countries out of 49, which already acceded to MLI. For example, such countries as Belgium, France, Poland, Slovakia, and Slovenia have applied this provision to their double tax treaties. Ukraine is also among this list, and let us see if Russia and Kazakhstan are also present here.
So regarding Russian situation, I would like to comment that Russian tax code originally contains a similar provision. However, it was not in most of double tax treaties, and when double tax treaty was implemented, the provisions of Russian court were not taken into consideration. But for example, in double tax treaty with Cyprus, such provision was mentioned before. So it was implemented in practice. Now, this provision will be added to many double tax treaty and will be more widely implemented. For example, Russia will use this provision with such countries like Ireland and Malta.
In Kazakhstan, Kazakhstan also accepted the provision of ownership period for 365 days. And based on matrix, we see that together with Kazakhstan, 18 states also accepted these provisions. So we will apply it.
Thank you, colleagues. Moving forward to the next part of MLI treaty. This part is dedicated to provisions which counter certain practices that try to avoid the status of permanent establishment. And the first article is Article 10. It contains the rules against tax evasion by creating permanent establishment in third jurisdictions. Just for your understanding, describe the following example. There could be a situation when there is a company in one country which creates the permanent establishment in a third jurisdiction, which has some beneficial tax regime for income of such permanent establishment. And at the same time, the income in the state of residence of the head office of permanent establishment also allows not to tax the income received out of permanent establishment. At the same time, this company derives the income from other jurisdictions, with which there is also a double tax treaty in force, and according to normal provisions of double tax treaty, some beneficial taxation rate of withholding tax has to be applied by payment of such income. So this income can be dividends, interests, royalties, or some other. And at the same time, this income is attributed to the permanent establishment, which, as we know, is located in a third jurisdictions where it is not taxed. And out of this, there will be practically no tax paid from this income. So it is not paid in the source state or paid at very low beneficial tax rate. It is not taxed in the third jurisdiction where the PE is located, and it will be not taxed in the state of residence of the head office of this PE. So in order to avoid and counter such practices, the following rule was implemented. It says that, for example, if we have the situation like on this picture, the company A is a non-resident, for example, located in Ireland, which creates the permanent establishment in Singapore. And to this permanent establishment, the income is attributed with the source from Ukraine. For example, it is interest. And in this case, Ukraine will not be able to apply the beneficial reduced tax rate to such interest if under the conditions of the local legislation in Ireland and Singapore, there will be no taxation on Irish side, and the tax rate in Singapore will be less than 60% of the tax which would be paid in Ireland, for example, if it would be the PE would be located there. So as within such schemes, it is quite often that the jurisdictions which is chosen for permanent establishment has a very low tax rate or even no taxation for the income attributed to the permanent establishment. It will be a good instrument to prevent using the beneficial tax rate in the source state, which in our example is Ukraine. So here you see the conditions. The permanent establishment should not be subject to taxation in the state of residence of head office, and the tax rate in the permanent establishment location has to be less than 60% than those in the head office state. This provision is implemented by already 13 states out of 49. For example, Russian Federation, Slovakia, Slovenia, Armenia, and Japan. So Ukraine fully applies this provision, and let us see if Russia and Kazakhstan also do this.
So for Russia, this provision is totally new. It is interesting how it will be implemented starting from the 1st January. Russia have chosen to apply this provision with such countries like Argentina, Armenia, and Netherlands, and some other countries. Maria, what is the situation in Kazakhstan?
In Kazakhstan, actually, Kazakhstan is silent in its ratification note about applying the provisions of Article 10. And however, in Matrix, MLI Matrix database, we see that about 10 states with Kazakhstan, they are going to apply provisions of Article 10 from point 1 to 3. And so actually right now I cannot answer clearly whether it will be applied by Kazakhstan or not, because on ratification note, we have no information about it.
So taking into account that MLI comes into force for Kazakhstan just today,
I think
we will need a bit time.
Colleagues, next slide is dedicated to Article 12, which is about artificial avoidance of permanent establishment status through commissioner arrangements and similar strategies. Similar provisions were containing before in many double tax treaties. They are related to formation of permanent establishment when the company in the in other jurisdiction has agreement with the other countries, with the other company, according to which this company represents another and concludes agreement, and with such status it creates a permanent establishment for the other company. Sometimes the contracting party were trying to avoid recognition of these contractual arrangements as permanent establishment creation. So I would like to describe this situation on example, which is on the next slide. So as you see, there is a company A in the foreign country registered, and there is company B and company C which enters into a contracts in Russia with the company 1, 2, and 3 on behalf of the company 1, on the company A, which is located in the foreign company. Sometimes the real negotiation process was conducted in Russia by company B and C, but the contract was signed abroad by company A. So when the agent, company B and C, systematically concludes contracts or plays the main role in conclusion of contracts, it will be considered that a permanent establishment is created. Please note that not only signing the contract is important in this case. The important is this provision, main role in conclusion of contracts. That means that all necessary provisions were negotiated by legal entity located in Russia in this example. In this case, it will be considered that company A created a permanent establishment in Russia through its agreement with company B and C. This provision will be applied to double tax treaties which Russia concluded with such countries like Argentina, Armenia, and France, and some other countries. So Artyom and Maria will share with us the status in Kazakhstan and Ukraine.
In Kazakhstan, we already had provisions on dependent agent, and from accepting this MLI article, we see here more detailed description of dependent agent and also its regulation on related parties. Together with Kazakhstan, already 17 states accepted this provision, so we will start applying this.
So in Ukraine, this provision will also be applied, and in such double tax treaties as the ones with Armenia, Belgium, Denmark, France, and Turkey. So the next article is dedicated to artificial avoidance of permanent establishment status through specific activity arrangements. It is quite extensive. I would say let us divide it into parts and explain what is discussed in this article. So first part of the article contains the list of activities which do not lead to creation of permanent establishment in particular jurisdictions, in case there is a permanent place of business where these activities are performed. Out of this, the provisions of MLI, it is possible for the state to include, to choose further options. Option A includes all the activities which are of preparatory or auxiliary character. Option B includes not only the activities of preparatory or auxiliary character, but also other activities. And it is also possible not to change the provisions of double tax treaty because in all of them there is already a list of provisions which make the exemption of for the PE status in case of performing certain activities. After the state has chosen their option, there is also a general rule which says that it is called anti-fragmentation rule, and it is general for all the states which implement the treaty. This rule says that still, even though there is a list of activities exempt from the permanent establishment status, it is still possible not to accept non-existence of permanent establishment in the following cases. So if the place of business constitutes a permanent establishment in the same jurisdiction where this activity is performed, or there is another enterprise which closely related to the one performing this exempt activity. Other condition is if the overall activity which results from combination of exempt activities turns out to be not of a preparatory or auxiliary character. And another requirement which is the same for the first two, business activities constitute complementary functions that are part of cohesive business operations. Let's take a look at the example. It will be clearer what is meant here. So let's imagine there is a company A outside of Ukraine, which already has the permanent establishment in our state, and in addition it conducts some preparatory or auxiliary activity. So in this case, taking into account the permanent establishment is already present, these additional activities will also create the permanent establishment. Other example, there is not only company A, but closely related company B, which together with the company A conducts certain preparatory or auxiliary activities in Ukraine, and under conditions that altogether these activities of both related companies are resulted in a cohesive business operation. All these activities create a permanent establishment in Ukraine. Other example that could be discussed here is, for example, there is a bank outside of Ukraine, and it has several branches on the territory of Ukraine, which are already a permanent establishment. But at the same time, this bank has some kind of a data center, which receives the information from these subsidiaries and analyzes the applications for credit obtaining. Based on analysis of this information, the decision is taken whether the credits should be provided to applicants or not. So you can see that there is an example where there is a activity which leads to permanent establishment, and there is a auxiliary activity. But at the same time, both these activities constitute cohesive business operation, which is granting of credits and loans to applicants. So altogether, these activities will create the permanent establishment for such bank. this provision is not very popular after the analysis of the other parties to double tax treaties with Ukraine, which accepted it, but such countries as Armenia, Belgium, and Croatia also will implement it in their double tax treaties. So, colleagues, what about your jurisdictions?
In Kazakhstan, we already chosen option A for applying, and together with us, 15 states also accepted these provisions. What we see else that 20 states together with Kazakhstan agreed to apply Article 13.4 and to insert it and suspend the article regarding to permanent establishment. Katya, what about Russia?
So Russia also have chosen option A, and this provision will be applied to several double tax treaties with such countries like Argentina, Armenia, and Netherlands.
Okay, let's go further. And here we have Article 14, separation of contracts. What it states? It states that, for example, if one enterprise and with another enterprise with which they are closely related and which are making under the contract activities on one facility for exploration and production of one construction site, and duration of such activities are more than 30 days. In this case, the days of the second party will be also calculated for 12 months period for the first enterprise. This is done to avoid ambiguous interpretation of calculation of period. And here on the next slide, we will see as an example how it will work in Kazakhstan. For example, company A and company B are non-residents, and for Kazakhstan, they are closely related, and they are going to make on one facility activities duration of which for 6 months. What we see here that by the activities of two companies, these activities will lead to creation of permanent establishment on the territory of Kazakhstan, because in total the duration will exceed 12 months period. Together with Kazakhstan, already 11 states accepted these provisions. And from my side, I just wanted to mention that we already had previously a similar position in Kazakhstan tax code when we look at the permanent establishment creation from the side of related contracts. So now we will see here about not contracts, but related parties in one contract. Colleagues, could you please share your position regarding these provisions in your countries?
So for Russia, this provision is something new. There was no such practice before. Even tax authorities didn't try to prove some misuse of double tax treaties. So it will be new practice. This provision will be applied with such countries like Ireland and Netherlands.
For Ukraine, this provision is also a new one, and it will be applied for the double tax treaty with such countries as Lithuania, Romania, Russia, Saudi Arabia, and Slovakia.
Okay, thank you.
So colleagues, we move to next provision, which is related to mutual agreement procedure. When a taxpayer has doubts regarding that his right was breached by actions of some government bodies in one of the countries, it has 3 years after it happened for apply to any of two government bodies in each state. Means it can apply to the government body in the state where it has residentship, or to the state from where incomes derived. So mutual agreement procedure is aimed to resolve such disputable situation when the income was taxed not in according with the double tax treaty provision in opinion of this legal entity of or physical person. In Russia, we had in several double tax treaties such provision before, but it was not really implemented. However, starting from 2020, there was changes in tax code, according to which the procedure of mutual agreement should have been implemented in Russia. It is said in Russian tax code that the relevant process will be established by acts of Ministry of Finance, but till now there was no legal document which stipulate the order of this procedure. So actually it is not working. Let's hope that it will be changed in the future. So colleagues, how is it in your countries?
In Kazakhstan, we actually already have such provisions in our double tax treaties, I suppose in Article 25. And as Katya already mentioned, it doesn't really work right now, and we don't have actually an internal methodology how it should be worked in Kazakhstan. Artyom.
For Ukraine, this provision is rather new. Our state decided to implement the Article 16 into the double tax treaties. And in addition, there were changes to domestic tax legislation, which also provided a certain procedure for mutual agreement procedures. And that's why from now, this will be not only the formal process, which nobody knows how to implement, but as well there will be some order and some instruction what to do if it is there is a case which can lead to a mutual agreement procedure. So dear participants, that was all regarding the positions of the double taxation treaties covered by MLI provisions. And now we say a couple of words about our services which can be used in the situations caused by the new implementation of new convention.
Dear colleagues, as you see, the MLI Convention and its implementation is a very complicated issue. So we can help you in studying these new provisions and understanding how they will be applied. At first, we can check contract provision at the stage of negotiations and to advise you how it's better to implement some positions of MLI and which changes should be introduced in the draft of the contract. We can provide some recommendation regarding deal structuring so that you will be able to apply reduced tax rate and you will have all tax benefits which are provided by double tax treaties and MLI. We can consider your defending strategy and prepare a defense file. Usually, we see that there are cases when a tax authority can try to challenge the position of the company of implementation of reduced tax rate. In this case, we can foresee what kind of documents will be requested by tax authority and prepare them beforehand, because when you have such request, you have only 5 to 10 days to prepare such documents and file them with tax authority. If you have these documents prepared at the stage of performing the transaction, you will be ready for tax audit beforehand. So, and as far as the MLI will change the whole structure of double tax treaties, we can provide recommendation regarding corporate structure of your business together with our legal department. We can consider it and see what kind of provisions of MLI will affect your business and recommend you which changes should be implemented. I have seen that in question and answer section, there was a question regarding double tax treaty between Russia and Cyprus. So I can provide comments that already the agreement regarding introduction of changes in double tax treaty between Russia and Cyprus was already signed in September, and as I have seen, there was already the text of this document. There will be provision according to which the dividend tax rate will not exceed 15%, and there will be some cases when the companies will be still able to use 5% tax rate. So we expect that both countries will ratify this agreement before the end of this year, and the relevant protocol will come into force starting from 2021. Regarding the implementation of MLI between these countries, I have went to by the link which we have given in the starting of our presentation, which is MLI matching database, and have chosen Russia and Cyprus, and have checked that these the both countries will use MLI, and some articles will be implemented, some of them not. So if you need to see what is the status, you have to go by this link, choose Cyprus and Russia, and compare them, and you will see which articles of MLI will be implemented and which options both countries have chosen, and you will get the total status of convention.
Dear participants, are there any other questions? So as I see, there are no additional questions. We are through with our presentations, almost in time. Thank you for your attention. We hope our webinar was useful for you. If you have any additional questions to follow up, please use our contact details and we will gladly answer them. We will be also glad to see you on other webinars and online events of Schneider Group. Stay safe, stay healthy, and see you next time.